A very good evening to you and welcome to this special edition of Politics 101. Today we are going to be discussing the recently handed down verdict on the elections petition. Well, one of the elections petition, the one that challenged the constitutionality of the recount order 60. We did promise that we would review the ruling once it was handed down. And we have our regular panel here tonight, Mr. Roysdale Forde, who is a member of parliament, Khemraj Ramjattan, the leader of the AFC, himself an attorney and member of parliament, and Mayo Robertson, who is an attorney. Mayo was directly involved with the case, so was Roysdale, and I'm sure that Khemraj was part of the larger team. Gentlemen, welcome to Politics 101. Let's not waste any time and get right into the program. Mayo, I'll start with you. Please bring our audience up to speed as to what were the central questions before the court. I think you have to unmute. Yeah, we're hearing you now.
You hear me now? Okay.
Yes.
Good evening, David, and good evening to your audience. Petition 88 challenged the recount on the basis that the order that enabled the recount got its power from legislation that we believe was unconstitutional. Specifically, Section 22 of the Election Law Amendment Act, which is Act number 15 of 2000. And Section 22 purports to give to GCOM the ability to amend any law, to change any law, as is deemed by them necessary to resolve any difficulty that might arise in GCOM's carrying out its functions under the Representation of the People's Act, Representation of the People Act, or related legislation. We believe firmly that the power given to GCOM by Section 22 is so wide that it violates the principle of separation of powers. And that principle, simply stated, means that the government is divided into three parts: the legislative part, which is Parliament; the judiciary, of course, the judiciary makes rulings on the law; and the executive, which would be the cabinet that puts the government's policies into effect. Now, we believe, and the Constitution supports us, and the constitutional history supports us, that legislating falls within the responsibility of Parliament. With very little exceptions, the executive branch is not allowed to make law. And strictly speaking, the judiciary doesn't legislate. They tell us what the law is. They declare the law, but they technically don't make law. The only way the laws are supposed to be promulgated and amended are through Parliament. And Parliament can delegate that responsibility only in a very, very limited context. We say Section 22 of Act 15 of 2000 therefore infringed on the doctrine of separation of powers, and it impermissibly allowed the GCOM to carry out a function that should be the restricted premise of the legislature. Now, Order number 60, on its face, stated that it derived its power from Section 22. And our contention was that since it derived its power from an unconstitutional law, then that in itself was unconstitutional. And Order number 60, of course, order that was published to allow the recount, which eventually led to the declaration of a result of the March 2020 election. So in essence, we have an unconstitutional law that gave birth to an order which we believe was therefore unconstitutional. And then that order gave birth to the recount. And our position was the entire recount process was flawed because of how it originated.
Khemraj, anything you want to add there in terms of the central questions that were placed before? You have to
unmute.
Yes, yeah. We're hearing you.
Yes, it is essentially that was the core point about this case, 88, Petition 88. David, the Constitution is the supreme law of the country. The Constitution has certain institutions that can make laws, like the legislature, and the legislature, in its wisdom, has made laws for the good governance and good government and peaceful government of Guyana. And these laws include the Representation of the People's Act and a number of other elections laws. And they made reference to that which is to how GCOM must conduct its business, how the announcement of the results must happen. And in our law, the strict legal regime was that the declarations of the returning officers must be the basis for the results coming out from an elections process. Now, that is the legal regime that is very much fixed. And that was basically the question, whether you can now go, notwithstanding the very, what one might call the peculiar nature of the last elections, whether you can go outside of that legal regime of declarations from returning officers and go and order a recount. The agreement to go and order a recount does not necessarily, and that was one of the big questions there, was not necessarily a process that would legalize or constitutionalize that process. And that is what the lawyer was arguing, that, okay, we have a legal regime that says declarations must flow for the results of the elections to be announced from returning officers. There were problems. The problems now created an agreement. CARICOM, president, leader of the opposition, and that necessarily means that the recount must be the basis. That is what the PPP was arguing. We are saying that no, that could not be the case. And Jeremy did it very compellingly and cogently, in my opinion, that indeed this does not constitutionalize or legalize it. We have precedent here in Guyana whereby, and I think I have said this before in one of your programs or some other, I don't know if it's Mark Benchcop, but it is clearly a case where we have a precedent in Esther Pereira, which made it clear that although agreements between the PNC and the PPP at that time was to the effect that you must have a voter ID card to vote, Justice Claudette Singh ruled in the Esther Pereira petition of 1997, I think it was, that you can't agree to do things outside of the legal framework. So although we agreed, and then we went to Parliament, and I was a parliamentarian, and we passed a law to say that you can't vote with your old ID card. You can only vote when you over 18, you're registered, plus now you must get and go and collect a voter ID card after you do that process. Esther Pereira, I think the position was that she didn't have a voter ID card, and she said that the Constitution says that I can vote on two requirements, being over 18 and getting registered. And although the PPP and the PNC agreed for a third requirement of a voter ID card, that made the entire elections unconstitutional because it was conducted unlawfully. Now, in an identical situation here, and well, it is not all four squares, and you know, but it is by analogy, and that is how lawyers argue and carry the law for them. We adopted that agreements cannot legalize or constitutionalize certain things. What the Constitution says, or what the law, apart from the Constitution, that is like legislation and so on, what they have, which is consistent with the Constitution, those are the laws that you must allow to be the process and procedures for the announcement of it. We are saying now that this Section 22 that gave the Elections Commission this extraordinarily broad power to go and right wrongs was a power that was given to it that was ultra vires the Constitution, and that it could not have been used to do a recount. What is the legal regime is that the declaration should have been made, and those who are vexed with the declaration, they can go under the legal regime again to an elections commission, bring their numbers there, and then have the elections vitiated and made null and void, like what happened in Esther Pereira when Justice Claudette Singh ruled that a voter ID card made the entire process null and void. Now, basically, that is the crux and core of the matter. And I would like Senior Counsel, if he's there, to say a little more. But this aspect of the matter has to deal with a very fundamental doctrine of constitutional law. And that is the doctrine of separation of powers. If we have to make a new legal regime to deal with elections and the announcements of results in Guyana, then we should have gone back in Parliament and to say that returning officers' declarations are not the basis. And you might have had to amend the Constitution or amend the legal sections that deal with the declarations of returning officers. And so you could not have given an executive body so much legislative power as the Order 60 did by virtue of a certain section. So we were saying that section is unconstitutional when it gave so much power to the GCOM. The order itself was illegal because it was ultra vires. And therein lies what our argument was. Of course, if I may take it, by the way, is Senior Counsel Roysdale there?
No, Roysdale is not here yet. He'll be coming in shortly.
Okay, because it would have been important for him to also let us in to all these arguments. By virtue of what we are saying here is that when the declarations would have been made, of course, the PPP and the international observers were saying that it was all messed up. We are saying that the legal regime has a remedy for that. If they wanted, they could then have gone to the court, the High Court, for what is called the remedial action to be taken, that is, by petition, getting the elections null and void. And that is basically what the questions are here. The PPP lawyers, however, argued that that section 22 and the order that was made that gave it all these ancillary powers is legal and stemmed from the Constitution. And because it so stemmed from the Constitution, and they were doing it to, as the order says, to remedy certain challenges and difficulties that came about, that it was not unconstitutional. And that argument by them is what the learned judge followed, instead of what we were saying in a very legally puristic way, that the law here was not, the order and the section 22 was not in keeping with that. You can't get a GCOM legislating. Only Parliament, that institution of government that can make laws, should do that. And so the delegation is totally improper and illegal. Of course, the judge went along with the arguments made by the lawyers to the other side. And we now, well, of course, will want to cogitate and discuss and certainly, I feel, want to file an appeal against the decision. Now, whatever, as I will repeat again, David, whatever it is that the courts in the hierarchy will say, it will also help to bring these two things, finality and certainty, to the law. And our jurisprudence would be enriched as a result. And I do not like, and I want to make this as personal comments, people to go around cussing up the judge and making all kinds of comments. We are serious lawyers. We come up with serious points. Jeremy was extraordinarily good with his articulation of that legal point. It is a sound legal point, but it was not accepted by the judge. That doesn't mean necessarily that that is law. You in America, David, you would see that they would go through a certain court, and the lower level, go to the Court of Appeal divisions of New York, and then end up at the Supreme Court. And what the Supreme Court rules, that is what now is a statement of principle and law that we all will finally accept and go along with, because that is the big court, as it were, the boss.
Yeah.
And that is what we would want here. So I am asking people out there, don't start thinking that, you know, oh gosh, this woman has, you've seen the social media. It is not right. And we lawyers ought to let people know that that is but inflammatory. That could be even matters that could become, what's the word, contempt of court and so on. And it does nothing good for our institutions. If you don't like a judgment because it's perverse, file an appeal. And we have done that. I have done that against many judges, including the same judge. And you go to your high court, the higher court, and you will get your justice there if your point have merit, and if the Court of Appeal so feel which it has, or the CCJ.
Mayo, let me get you in here. Thanks, Khemraj. The judge did say that the outcome of the recount meant that the 10 declarations by the returning officers, or the 10 reports by the returning officers that were in abeyance, that once you had the recount, that they had been overtaken. Explain that, and explain what might not be correct about that.
Well, as Khemraj was saying, we have a regime, we have a set of election laws, principally the Representation of the People Act. And the Representation of the People Act describes how votes are counted. We start at the local level, those from the local level, each polling station, they send their reports into a returning officer. And there's a returning officer for each region, 10 returning officers in all. Then they send their numbers into the chief election officer. He uses those numbers to tabulate who the winner is, informs the chair of GCOM, and then we get the declaration. There has never been any amendment to that regime. And as the CCJ observed in a part of one of its judgments in these post-election cases, Order 60 couldn't presume to start a new election regime. Whatever else they were trying to do, the old regime still subsists. And the old regime tells you how you tabulate votes. It tells you how results could be declared. And our contention is Order 60 sought to throw that regime out completely and establish something new. There is a reason why the old regime is in place. For instance, returning officers are sworn officers. They have certain duties that they must meet. The people who supervised the recount, they were not sworn officers. There are certain procedures for objections. There's certain procedures for requesting a recount. All of that, all of those things are discussed in our representation of the people. And we do not believe to just throw out that entire regime without Parliament itself coming and saying, you know what, we're going to change the Representation of the People Act to reflect a new process that we think may work better. It is not for non-elected officials like GCOM in an ex post facto manner to come and change the way things are tabulated. Parties contest the elections expecting a certain set of rules that are set out ahead of time. It simply does not make sense. After the elections have been contested, parties expecting counts to be done a certain way, that, you know what, we're now going to throw that out of the window and impose a new way of tabulating. It's almost like, you know, in a football game, one team wins because these are the rules. You know, you kick a field goal, you get 3 points. A team wins by 1 point, and then they decide, you know what? Now we're going to decide kicking a field goal, you get 5 points after the game is finished. You can't do that. Election was over. The election was contested on principles set out in the Representation of the People Act. This is how the votes are tabulated. This is how a declaration is made. And it would seem, just on the face of it would seem unfair after the process is over to try to create a new regime for tabulation. We think that is precisely.
Let me ask you this, Mayo. Do you disagree that GCOM should have some latitude to correct some things that may go wrong during an electoral process? Do you agree that GCOM should have some leeway to correct some things?
Of course.
Uh-huh.
For instance, if the rules say that election day the polls shall be open from 8 a.m. until 6 p.m. But in one particular polling district, you couldn't find the keys for the schoolhouse or wherever the polling was going to be. And they couldn't start casting votes until 1 o'clock in the afternoon. GCOM should have the authority to say, what, in this particular situation, let us use our discretion to extend the voting hours. Little things like that that are not specifically catered for in the Representation of the People Act. We believe those are the kinds of things that GCOM should be allowed to improvise. In situations where the law specifically speaks to concerns raised. The law specifically says if you have a problem with whether the elections were lawfully conducted, then you file an election petition. It's already there. There was no need for GCOM to have to improvise. The law says how a recount is done, how you request a recount, who decides if you get. There was no need for GCOM to improvise. It's there already in the law.
Yes. So there has to be a limit to what GCOM can do. You're saying there is a limit to what GCOM can do.
Let me try my other phone.
There is certainly a limit to what GCOM can do, and it would be absurd for us to say that GCOM cannot exercise some degree of authority and autonomy to resolve unforeseen difficulties that might arise in the execution of an election. Because things could happen, and the legislatures could not have thought of every possible difficulty. So somebody has to be able, so as to avoid a logjam, to avoid a crisis, somebody has to be able to improvise where the law is silent. But our position is, when the Representation of the People Act tells us what to do, then we do what it tells us. This was not any unique situation. This is one of the things that is most easily foreseeable, that you're going to have elections, somebody's going to be unhappy. Somebody's going to allege that in some district this didn't happen. Somebody's going to allege that the votes weren't counted properly for them. That was anticipated. And that is why you're allowed to file an election
petition. So the central argument here is that GCOM went beyond its discretionary authority in this case, and hence creates a new regime, supersedes settled law, and supersedes the function of certain institutions. Let me bring you back here. What occurred as far as the recount is concerned? Would you say that in effect, what happened there is that the recount replaced a petition?
You're asking who?
You, Khemraj.
Yeah. Well, yes, that is exactly what we are arguing here, because the judge, and the lawyers to the other side have been arguing. But what if there is egregious conduct on the part of a returning officer? Well, we are saying that you got to go by elections petition.
Yes.
And that is also with a precedent, David. It happened to the Alliance for Change. They made a fundamental computational error in relation to the votes at Region 10. And a lot of people inside of the PPP now want to erase that from the history of the precedent in relation to elections. A very good chairperson in the name of Steve Surjbali, and I want to say a very good person in Gokul Budu. They were the CEO and also the chairperson of GCOM. We went with our statement of polls indicating to them that, look, we won 800 more votes than the PPP, so we should get this second seat in Region 10. And you know what they said? That the legal regime as it is, which states that once the declaration is made by the returning officer, that is what must, and you, Ramjattan and Raphael, must go to court with an elections petition. So we said, well, what kind of madness is this? And they said, well, that is now the precedent. It was always like that. you know, and this is the kind of thing that, you know, that sometimes bring on anger when there is certain discriminatory methods how you apply the law. In our case there, they said go to the court because returning officer Region 10 declare the results and the PPP win the seat. And Sam Hines gone and sit down for the seat as Prime Minister. I said, well, okay, if that is the legal regime, and you have that, if I now can prove that their mistake was made, that would have given us that set of votes that will get, we'll have to go to the elections petition. And we went. It took 5 years. Up for hearing. You know, and this is what we are saying. So an elections commission must know its precedent in the administering of elections, and not when it comes up now in relation to the matter that the PPP now jumping on. We went to the international observers and all of that in 2006 and tell them, show them. Not one of them say anything. They say, well, the RO, that is the legal regime. You know, this thing, you know, is a fact of history that we know was cheated. And we went the legal regime way, and now they did not want that. So I see the merit, you know, the argument having merits, and why, you know, I feel compelled by it. And a lot of people could say, well, okay, that Region 10 RO did a lot of wrong things and this and that and whatever. Well, as this fella came out with a beautiful interview, Vincent Alexander, that said he come out to have scrutinized the declarations made by the RO of Region 4, rather than go and be compelled into activities by the international observers.
Yeah.
I respect our international observers, but they must know their place too, just like the doctrine of separation of powers we're talking about here, about the judiciary, legislature, and the executive branch. They being observers, they must observe. And then they go write up the report. But you know, a lot of things happen. You even say about the Canadian High Commission and a number of things and so on. I mean, I wasn't there, but I want to believe Vincent. Vincent is a very credible witness in my eyes. And then I saw a number of things happening there. I even went across and I met Mr. Quinn and I met Sarah Ann Lynch on the upper flat. And I indicated to them that, look, things will go in accordance with how free and fair and credible elections must go. And then I left them there. But the trouble is that when you know this lawyer is making all these good arguments, you know, it kind of is baffling that now you're going to say, well, this they could remedy it before an elections petition is filed. But that is what we want finality and certainty for.
Roysdale Forde, Senior Counselor, is here. In case you're just joining us, this is a special edition of Politics 101. We are taking a look at the recent ruling of the court. We don't want to get into the arguments of the court because there's a possibility that the case would be appealed. But we want, for the benefit of the audience, to get a sense of where we are. Roysdale, can you, where has this left us? You know, some supporters are questioning the fairness of the court. Some people are pointing the question of regime change and that the court has become caught up in all of this. Where does this ruling, which if we listen to the arguments that your side made, and the explanation here this evening, really raises some very serious problems going forward. Because if GCOM is going to have these wide powers to change the rules of an election, basically, then in any election from now on, anybody can say, I see something wrong, and get GCOM to change the rules to correct that wrong. Where does all of this leave us, Roysdale?
Good evening. Thanks for having me, Dr. Hines. And good evening to the listeners and my colleagues here. Um, Dr. Hines, you would recall on your inaugural show, the three of us appeared. And one of the points I made on that show was the danger that the course of conduct that would have been employed by GCOM um, and the possible implications it could have for electoral democracy and the future stability of Guyana. You would recall in that show also, Dr. Hines, I told you and the public that imagine 25 years away, um, these strange and bizarre possibilities that I had outlined. But we don't have to wait 25 years now. I said that 25 years in a strange um, expectation and the possibility that some future commission would have repeated it. But since that time and since then, the court has delivered a ruling. The ruling has really given effect and given light to the possibility that what happened in the elections of 2020, the conduct of GCOM, is now lawful and can be repeated at every single election, ranging from local government election all the way to national and regional elections. So the fear that I had outlined there was a reasonable fear, and it is a fear which has been given life to by the decision of the court. It is very bizarre to have a situation where an elections commission, as Mr. Mayo Robertson would have said a few moments when I joined, to have an election commission, sorry, do all the work that is necessary um, for the court, um, come to conclusions, make decisions, change the validity of the process to be employed, and in so doing, even change the validity of votes, the process for counting votes, and for it to be sanctioned by the court as being um, lawful. But what we have, is a really sort of comedy. Is a comedy because we would have applied to the court um, during the electoral process, during the period when these issues were being raised and ventilated before the court, and we were being told then that we have to come by way of an election petition. We have now filed an election petition, and we're being told, without, in my view, with respect to the judgment of the court, without any serious analysis as to the arguments presented by us, um, that that the court has now found that the process that we have complained of, a very process which the Elections Commission itself indicated that it had some uncertainty in terms of the ramifications and the range of what it was doing, sanctioned and upheld by the court. But I know, I haven't heard the entire discussion so far, but I know for a fact that Mr. Ramjattan and Mayo would have mentioned to you and the public at large the issue of the separation of powers.
Yes.
No, Dr. Hines and members of the public, this is a fundamental issue. Um, you may want to consider this as a sort of standalone issue, but it is a fundamental issue in relation to our constitution, relation to GCOM, and relation to almost every aspect of the operations of the government. Now, Dr. Hines, the Privy Council in 1975 delivered a landmark decision called Hines against the Queen, in which the Privy Council brought out the principle and gave effect to it of the separation of powers in the context of a written constitution. In that case, the issue was whether the Parliament of Jamaica could have enacted a law which would have taken away the jurisdiction of the High Court and I believe vested in a court they call the Gun Court.
Yes, I remember that.
And that Privy Council, I think it was Lord Diplock, it was, delivered a profound decision which has been upheld around the world, even in countries that don't follow the Commonwealth or common law jurisdiction. Is a landmark decision, a seminal decision, which says simply that you can't take away powers from one entity and vest them in another. Now, Dr. Hines, what we've had happen here was historic. It's historic because the fundamental raison d'etre of the decision of the court has been to slam a hammer against the decision of Hines against the Queen. We are now saying that fundamental powers vested in one organ of the state could be transferred to another constitutional entity. It is outstanding. as it is strange. Um, I don't believe that any of the cases cited by my friends on the other side, and I haven't seen the judgment, but from what they would have been read, dealt with this situation. We would have outlined in our written submissions to the court that this wasn't just a peculiar situation of Parliament delegating law making powers to the Elections Commission. It was much more than that. This was a power conferred specifically by the Constitution on Parliament, and those powers are incapable of being delegated. Now, Dr. Hines, as an academic, you would have listened to this decision and you would have seen, in my respectful view, not a sufficient analysis or no analysis at all on the issue of the nature of the power which is purportedly being delegated, and not whether Parliament can delegate power. So, obviously, Parliament can delegate power. Parliament has delegated power before in terms of making subsidiary legislation. But what had happened in this case here that made it so strange and against the Constitution, against the norm, is that this was a power which is incapable of being delegated. And then it was being delegated by a process which would have allowed not the receiving authority or entity the power to make further legislation, but the power to correct, amend, or even modify substantive legislation passed by Parliament pursuant to a power that is incapable of being delegated. So I hope that I would have captured Dr. Hines. I know none of my learned friends that would have dealt with the issue so far, but I believe that this is the fundamental plank in which the decision comes up short.
Right.
As an attorney at law and practicing with like my other friends here, we would present cases and we would lose. We would present cases and win. We would present cases and win which we didn't even expect to win. But this case here is a fundamental of importance to the country. It is a strong argument, is an argument backed by authority, and I don't believe that it was an issue on our part in which we failed to present the court with the information and authorities necessary. I can't explain the decision without everything you can explain. The rationale, but as a professional and as an academic who would have studied law, I believe that the decision on the major issues have not offered us any pathway forward.
Yes, and that is why you answered the question. I asked you the question, and I'm staying with you because I want to ask you a very important question. I was on a program this morning, and I have the greatest of respect for Justice George. But I find that this case was not a straightforward case, is not a straightforward case. It's a complex case. It involves separation of powers. It involves delegation of powers. It involves stretching the functions of one institution to its limit, to the point it can upset the entire architecture, electoral architecture. And because of the complexity involved, I would have wanted a more nuanced treatment of the issues. I've not seen the written statement by the judge yet, but I listened very keenly to the ruling, and I felt it was minimalist at best, in that it basically says Section 22 grants this power to GCOM. GCOM used it because there was a problem. Bingo, that's it. And I think the case involves more than that. One needed what I call a maximalist, a broader perspective to be brought on these colliding issues that have been raised there by the court. And that is what disappointed me. And what really shocked me more than anything else was when the judge said that your side, the petitioners, did not present a shred of evidence in a case, in my layman's view, a case in which you weren't required to lead evidence. This was a case strictly of law. One of the daily newspapers actually quoted it. CJ throws out APNU AFC petition, says recount order constitutional, no evidence presented of irregularities. Of course, the article does not even question that last part, no evidence presented of irregularities. Am I crazy that something is wrong here? Why did the judge find it necessary to introduce that element into the case? Roysdale, I'll stay with you, but I'll come to the other on this. You take the first shot at it.
It is one of, Dr. Hanks, is one of the things that I am baffled about. Since the delivery of the decision and moving around Georgetown, the streets of Georgetown, people have been asking me, Mr. Forde, Roysdale, Senior Counsel, MP, whatever appellation they want to put, why had no evidence? And I would remind them that this case was premised on the presentation of a legal issue. And we presented to the court the evidence which would have been appropriate to a finding by the court on this issue. Dr. Hines, the election petition is not simply an academic process. It flowed from real events which would have occurred. Even when you write an exam for law and you do a problem question, the examiner will present to you with the basic facts for you to analyze and present an answer. And that is what we would have been doing before the court. We would have told the court that we filed this petition, it raises these legal issues, and we would have filed a petition outlining the facts and the basis upon which we would have brought it to the court. And we would have attached to that petition the necessary documentation as exhibits, exhibit A, B, C, D, E, and F. And those would have been documents which would form part of the case from which the legal issue arose. So when the Chief Justice said that there was no evidence, I am quite unclear as to what would have been the meaning of that. In relation to the issues that the court had to raise, yes, there was evidence to support the contentions made in the petition. And I would disagree with the Chief Justice with respect in relation to that. If the Chief Justice meant that there was no evidence as to what took place during the recount to highlight the irregularities, the inconsistencies, the anomalies which would have taken place during the recount, I would concede that. But my concession does not impact on the strength of the election petition as filed and I was being heard before the court, because no such issue arose in this election petition. So what happened during the recount and form part of the recount process did not form part of this petition. So it is an unfair statement to present to the public as if somehow the lawyers went wobbly head and did not bring the necessary evidence to support that in a petition that had nothing to do with those issues.
Yeah, Khemraj, I bring you in here because apart from being a lawyer, you were a practicing politician. What is there more in the mortar than the pistol here? Talk to me.
And I, as president of the bar for 2 years, and I think vice president of the bar for a couple more years, I can't remember how many. We have an unwritten code that we don't go around being, harsh with our judges. But that criticism just made, and I want to adopt that criticism, is a genuine criticism of the judge's reasoning. And I rather suspect that it had to do with the fact that, to add a sense of authoritativeness to what she mentions as her conclusion, she threw that in to say that there is no evidence. There was absolutely no need in a question of law case for any evidence. And that brings me to question probably whether indeed there was more in what you call the mortar than the pestle.
More in the mortar than the pestle.
But I would not even go there because of a tradition that we all must have into that. But it is a very, very serious criticism of what the judge analysis here. Because let me tell you something. When judges are doing these major matters of constitutional law, they have to be tremendously jurisprudential, sometimes philosophical. They have to wax heavy in relation to academia, because that is what is a fundamental pillar of our Constitution. And when it comes to that constitutional pillar, it necessarily requires lots more analysis than simply waving a wand and saying, I ain't see no evidence here. It is not the evidence. The evidence is already in the affidavit. Whether this section 22 empowers a scenario of a order 60, and whether the Constitution give them that power. Something like the 50 or so pages of analysis done by Claudette Singh when she was a judge in relation to this voter ID card thing. You cannot go and make laws by agreements and then come and say they're constitutional. And then you have to make a proper analysis of all these other cases like Hines and DPP, and even one that was done by that same lawyer, Astafan, on these issues of separation of powers. Because if you start creeping into the territory and encroaching upon another of the territory of the other, like what the executive branch can now and again do in relation to the legislative branch, when the, let's say, taxing laws must be passed by Parliament, and you get a controller of customs wanting to go and take fines and do all manner of things, unless the Constitution made an exception to that, then you are violating the separation of the doctrine of separation of powers. And that is what she ought to have gotten here, and analyze this thing, and then also deal with the question of what are the implications indeed. I didn't think she did all of that. And look, we wanted an early decision. We wanted an early hearing. She has granted us that. And so I can then squeeze that in as a point as to why we shouldn't be too harsh with her. But of course, make the genuine criticism that the fullness and the frankness that I thought that would be part of the analysis was not there. And so that is why this thing ought to go right up to the CCJ. And you will get the major judges of the Caribbean dealing with these issues, because any issue governing or touching and concerning the doctrine of separation of powers is so fundamental that we should have a ruling from the highest court of the land.
Mayo, let me bring you in here. You took the case during the impasse, the Yuli Moore case, and you argued in that case strenuously that this thing is unconstitutional, this order. And I think it was the appeal court that says that order 60 really introduces a new regime. Either they said that explicitly or hinted at that in effect it changes the meaning of a valid vote and all of those things. I think that remains the bugbear in everything that we are talking about here. And that in a way, in a backhand way, she seems to be making your case. She seems to be making your case when she makes that statement. Because I search my head since then. Why? She's a deliberate justice. She's very deliberate. She would not have made that statement by accident. But I can only think she's making your case that this recount really brought into being something new. And she's saying, well, why you didn't present that new thing here? All right. You know, anyhow, I am not a lawyer. I'm a political scientist, so called. Mayo, you come in.
Well, I would say fundamentally, it's a good thing we have a system where we have a hierarchy of courts. If judges were always right, we wouldn't need courts of appeal.
Mm.
As you know, being a historian of politics around the world, on these difficult issues, it is not uncommon to lose at the first instance. Uh, we expect our judges to be judges of goodwill, and we assume that they're judges of goodwill. But fortunately, we have a system that allows us to review work of other judges. And it's not uncommon at all for judges to be reversed in landmark cases. It happens all the time. I believe this was the first time that Section 22 was challenged head on. We had always taken the position that it was unconstitutional. We believe that Order 60 created a new regime which was not permissible. We'd always believe that. So, you know, when you have an important issue like that being ventilated for the first time, the first instance judge doesn't always get it right one way or the other. If the court had ruled in our favor, the matter would have been appealed, and it is important that it be appealed. So we disagree with the opinion of the learned Chief Justice. We're bound by it until it's overturned, but we disagree with it. And I don't believe there was anything in the decision that was read that made us think, oh my gosh, we forgot to say this, or, you know, we didn't think of that. We still feel satisfied, having heard the decision of the court, that the arguments we made were fundamentally sound. And that is why we will proceed after we've had an opportunity to review the court's appellate process. And like I said, judges are not infrequently wrong, especially on critical matters like
Thank you very much, Mayo. Roysdale, let me come back to you as we wind down. Uh, it's been hinted here that you all will appeal. Is that a final decision, or it's still being deliberated? Taking into consideration the argument that it is not constitutional to appeal a ruling by an election court. Roysdale?
Well, I could say this evening that it is a fixed and definite decision to appeal. We are fully in that mindset, fully in that frame of mind. We will file an appeal. We are awaiting the decision of the Chief Justice to have another look at it, to review it. But from what we have heard, from the notes that we would have made, from the general recordings that we would have seen expressed in the media, when we put them back together all again, we are firm in the belief that the decision ought to be appealed.
Thank you. And let me stay with you as we wind down to closing statements. And this is a political question. There are supporters of your supporters. They've lost in the court. They've seen the cases by their leaders being thrown by the courts. They've lost more than they've won. They are certainly feeling a sense of frustration. Khemraj broached the subject earlier when he talked about our institutions and trying to ensure that we don't tear down our institutions when we get a bad judgment. And I know there's been a lot of personal attacks on the Chief Justice, some abuse, and while the frustration is understandable, I want you all, each of you, to take this opportunity to really speak to your supporters and to try to give them a perspective that speaks to that frustration, but also speaks to the larger political project of holding our country together, preserving our institutions.
Dr. Hines, I would be the last person to encourage or support any attack on any member of the judiciary or any person whatsoever who would have made a decision exercising their portfolio and their authority. But I would always have the frame of mind to respectfully disagree with them. And I believe that that is what the Constitution and the entire bedrock of our system would permit. So I would encourage our supporters to express themselves, express their disagreements and their frustrations um, loudly, firmly, strongly, but respectfully, and within the confines of what would be appropriate and decent and of good taste. But I want our supporters also to understand, Dr. Hines, that we are in a struggle. And the nature of a political struggle during the court process requires continued support, continued operations, continued fighting, and a continuous battle. We have to understand historically, in relation to any successful movement, it was not achieved by doing a drive through a KFC. You just didn't turn up one day at a location and it was all delivered to you. You look at every struggle, the struggle against slavery, the struggle for civil rights, the struggle for independence in this country, the struggle, as some people would say, even for the restoration of democracy, the struggle for local government elections. It is a process. There will be setbacks. I'm concerned that our supporters too easily at times become too easily frustrated. They must understand that this is a system and the judiciary forms part of the system. We have no right to expect a judgment in our favor. The judgments are delivered. We must take it further and further and further at each stage. And we must remain mobilized and vigilant. That is what I want to tell our supporters, that we must remain vigilant and ready to stand up to protect and defend what is your interest. And going to court is simply one aspect of it. We would have gone to court, and people would say that you would have lost more than you would have won. That may be a fact, it may be fair, but they must understand that the effort and the fight and the resilience which went into those efforts is not going to go in vain.
Frank talk here from a leader of the opposition, one of my favorite Caribbean scholars, the Honorable Rex Nettleford, used to say, our struggle is not sprinting, it's long distance running. And it has to be long distance running because we're trying to build a new society out of the ashes of slavery and colonialism. And there will be moments when all would seem to be lost. We must not give up because it's not a dash. Mayo, you are not a politician here, but I will pitch the same question to you. Speak to the supporters in this hour of another setback. I wouldn't say a loss, another setback. Talk to them. You have to unmute. Unmute. You have to unmute, Mayo.
Sorry. Yes. You're correct, David. I'm not a politician, but I agree we have to take the long view of these things. And it is a matter of fundamental importance. And I think to make it a little more contemporary, we had last week the conviction of a white police officer for the murder of a black man. And that was a first. And there have been many cases where officers have been involved in the killing of black men and nothing happened. You don't even get them charged. But we didn't give up. We didn't say, you know what, we're not going to get anywhere because we lose every time. when you have an issue that is as important as this is, you cannot decide because of setbacks along the way that you're not going to pursue it to the end. We're just at the beginning of this. And yes, we did not get a decision in our favor. And yes, there have been other decisions we haven't gotten in our favor. But you know what? The cause is still important. And we shouldn't focus on judges in any capacity other than as judges. We have to assume that judges act in good faith to carry out their roles, because it is not a useful exercise, because no matter what we do, the judges will we can achieve our goal is to use the system that is in place, and that is the hierarchy of our courts. One judge disagrees with us, we go to the next level. They disagree with us at that level, we go to the next level. And that's the system we have, and that's the only system that can work for us. So I would urge people not to focus on the personality of the judge. I think the judges try their utmost best to render decisions that are fair. Sometimes we disagree with them, and sometimes we ought to disagree with them because it helps development of our jurisprudence. So let us remember that this is just stage one, phase one of the struggle. We're going to continue to fight, and we are confident that down the road, we will eventually be able to persuade our public that our cause was a just cause, and it was a cause that needed to be supported all along the way. Just remember those who supported the prosecution of Chauvin for the murder of James Floyd. George Floyd. Even after hundreds, perhaps even thousands of cases where officers have killed people, nothing happened. You go to court, lose. They don't indict them, you know, and even if they get indicted, juries don't convict them. But we didn't stop. Same thing here. Same thing here. We cannot afford to stop. Let our supporters know we are disappointed, but we believe that our cause is just, and we believe that the law is on our side. And as Khemraj said earlier, in any event, it's in everybody's best interest to have these issues ventilated so they can be pronounced upon with clarity for the future.
Khemraj Ramjattan, you have the last word here this afternoon among the panel here. Talk to your supporters. You have to unmute. You have to unmute.
I got a little prompting from you in relation to Rex Nettleford, and I would want to urge another set of great words that he famously titled as a book. We must, as a people, inward stretch so that we can outward reach.
Yes.
And we have to have, in this moment of disappointment, maintain our sanity. That must prevail, because we are a fledgling democracy. You have had in America there 250 years, and still you got all manner of gerrymandering and voter suppression and all of that the Supreme Court, great as it is, has not yet rectified and remedied so that we can have an even more perfect union. So it is fundamental that we understand the need for the institutions of governance to be respected, and that we fight on and struggle it through for purposes of getting even the better decisions that we would desire tomorrow. And so I'm asking supporters all across the country, please understand that you have a freedom of expression, because in my practice of the law, and I have done a lot of constitutional law, probably the other constitutional provision which is more famous than every other is freedom of expression. And freedom of expression means that you can be critical of even judges' judgments, but be respectful and decorous in your criticism. I don't want people to start slamming judges and doing all manner of things. But you can express yourself, because the judgments of judges rest on very sure foundations. And if you don't like the foundation of a one from a high court, then we can go to the Court of Appeal, and then we can go to the CCJ, and you bet. Even the CCJ, as I have said on very many occasions, the apex court can get it wrong. Remember, that court is only right because it is final. And just because we can't go any further away, we'll just have to respect it. But let us wait until that day. Thank you very much.
And thank you very much, Khemraj Ramjattan, leader of the AFC, Roysdale Forde, senior councillor, member of the coalition in Parliament, the person who's, I don't like the term shadow, but the person who is the alternative legal mind on that side. And Mayo Robertson, who I have known for a very, very long time. I'm glad you're back home and lending all of your experience to this process, this struggle. Thank you all very much. Thank you all very much for coming on. And
good night.
Good night. Good night. And I will have the final word. Let me just say here that I'm not officially a member of the opposition. The party to which I belong is no longer part of the APNU or the coalition. But the struggle to ensure fairness and justice is very much part of what I do on a day-to-day basis. And of course, the objective of the coalition in terms of democratizing the society is one to which I contribute, and the party, the Working People's Alliance, to which I belong, continues to contribute. One is not always on the inside, but one can also struggle from the outside. And that is what I'm doing here by affording a platform to those who do not have a platform. Because the media, the traditional media has been shut out from the opposition. And I am of the firm belief that when you not get more, you must suck granny. When you not get mama, you must suck granny. Those of us who grew up in villages know when mothers are not around, grandparents used to give the babies milk from the breast and so on. When you not got mama, you must suck granny. And so we are committed to ensuring that we have these fora for discussions. I know of the frustration. I know of the frustration with the system. I know of the frustration with our own leaders. I know that half of the population feel the grief to be marginalized from the process, to always be appearing to lose. It is not easy. I understand that very much. But like the panel earlier, I want to urge that we stay with the struggle, because indeed it is a struggle. I would be the last person to tell you, do not express yourself. Express yourself. But when you wake up tomorrow morning, know that the struggle continues. And if we do not struggle, we do not get any results. It was Frederick Douglass says that power concedes nothing without a demand. This morning on a program that I was on, some person said, David Hines is always complaining. And I had to retort that politics is about complaining. You go to the courts, you're complaining. When you take to the streets, you're complaining. We have to express ourselves and we have to complain and keep complaining. But don't always complain about the opponent. Also complain about ourselves. Because sometimes we contribute to our own malaise. And so therefore, yes, this is another setback. But God not sleep. God not sleep. You see? And we have to continue to have faith. To have faith in ourselves, to have faith in this piece of earth that God has put us all here on. And so therefore, let's press on. The courts must be one avenue of struggle, but there must be other avenues of struggle that we must develop. We must speak truth to power, as we are doing here, but we must also become activists, activists in our own way. And we can become activists without the direction of political parties. In our own communities, we must mobilize and organize our people to survive, because this is a very harsh period that we are going through, but we have overcome before, and we must know that we must overcome. Yes, we have to talk sometimes, because it is not the talking that is the problem, but it's what you talk and to what end you direct your talk. I want to say here this evening that we must resolve ourselves once more that we have to see this to the end. The other side would like us not to talk. They would like us to roll over and give up, so that we submit ourselves to modern day enslavement. That must not happen. I want to thank you all for coming on this evening for this special program. Tomorrow evening, we are going to be having, here it is, a discussion on the economy, the state of the Guyanese economy since the 2020 elections. A lot has changed in Guyana since the 2020 elections. A lot has changed constitutionally, legally, but a lot has changed economically. At the end of the day, we are entering into a new era where resources are coming into the country. We want to understand where those resources are, what has happened. And so Brother Winston Jordan and Brother Floyd Haynes are going to be on tomorrow evening for us to talk about the state of the economy since the election. Make sure you tune in for that. The flyer is out there on social media. Share it, please. Please share it so that more and more people will know that something is happening here in the evening, where in the old African way, we are ganga. We are ganga, because that's what our foreparents used to do. They used to gather under the kumak tree. And as the mighty sparrow said, looking for a brilliant escape from our miseries. And so we are going to be here tomorrow to talk about the economy. And then on Thursday, we'll continue on that vein, where the Working People's Alliance, the WPA, is organizing a discussion, a broader perspective on Guyana's 2021 budget. The budget debate in Parliament did not shed much light about what's in that budget, what is the meaning of that $397 billion, where it is being spent, where the emphasis is, and so on. Well, we are going to have a budget discussion here on Thursday. The WPA's executive member, Professor Clive Thomas, will be on the panel. We will have Mr. Dr. Tarun Khemraj, who is a young Guyanese economist who teaches at a university in the United States of America. Then we're going to have Kyle Greenidge, who is no stranger. The younger people will know him as the former foreign minister, but he was a former finance minister, and he knows the economy very well. And then finally, we'll have Sister Adriana Thomas, who has been speaking out openly in the newspapers, campaigning for social justice, and indicating that she will be a candidate at the next election for president. So we're having that budget forum on Thursday. And I want you to know that although the forum is sponsored by the WPA, of the 4 participants, only 1 is WPA. We have Carl Greenwich from the PNC. We have Tyrone Khemraj, our Indian Guyanese brothers and sisters whose sympathies are not with the coalition, but we feel that we need that voice. And then we have Adriana Thomas, who was an independent. So on Thursday, budget discussion. Tomorrow, the economy. Please make sure you all share these flyers and tell people it's happening here in the evening. Again, I want to say thank you all so much for staying with us to review the petition ruling handed down by the learned Chief Justice. And I hope you would have been able to shed some more light and some clarification for you. But more than that, we hope we've been able to rally you to stay with the cause. We'll cry today, but what? The Christians will say, joy cometh in the morning. This is David Hines saying, Bayeri, good night.